Welcome everybody to this special industry update. I'm Jill Cox. I'm a sales executive with Heritage Title. I'm here with Damian Cox today. And Damian and I started these industry updates. We've been doing these monthly now for years, but we started them back during the pandemic when there was a lot of confusion in the real estate world about what we can and can't do. There wasn't a lot of information out there. And this kind of feels a little bit similar in that regard. There's been a big shakeup to our industry. There's a lot of confusion out there. There's a lot of misinformation out there as well. So we want to be a resource to you, hopefully bring some clarity, hopefully some peace and some understanding to Colorado brokers about what this is going to mean for our industry and for real estate going forward. As I mentioned before, this is being recorded, so you can view this after the fact. And what I'd like to do today is kind of keep the chatter and chat to a minimum. And I want Damian to be able to kind of get through all the information that he has prepared. And then we will open it up for Q&A. So we will do our best to get through all your questions. But with that, let me turn things over to Damian. We'll get started. And thanks again for joining us today.
Well, good morning or afternoon, I guess it is, everybody. I want to lay some groundwork first. I saw that there was a comment about how nobody is going on the record on this. I think, first of all, there are a lot of people going on the record, but more importantly, I think there's a lot of concern that brokers are going to say things to implicate themselves or to undermine the settlement or to create other liabilities. And so I just want to warn you about, we cannot talk about commission rates in any form or fashion. We cannot talk about ideas you have for overcoming some of the challenges that we're going to face. And that's because this is all about antitrust, guys. That is the problem that we have here, is about collusion amongst our industry, or perceived collusion amongst our industry. I don't believe there actually was any. And I don't want to create another mechanism for somebody to say, oh, well, look, this is another proof of the collusion or anything else. So what we're going to do today is we're going to go through kind of talking about the NAR settlement, but what I'm concerned about is the talking points I'm hearing nationally may or may not apply to Colorado. So I want you guys to see where we are. I will tell you, I think Colorado is better situated than a lot of states because of the forms that we currently have, because of the form process we have through the Division of Real Estate. And so in a lot of respects, this isn't going to be a major change. And frankly, most of you have probably heard some of the things I'm going to be suggesting for years. And so this isn't going to be a big surprise. But I do want to kind of walk through some of the things that we're seeing. So with that, I'm going to go ahead and share my screen. Maybe. Okay, so here is my screen regarding the SAR. I think I got it right, didn't I, honey?
Yes, you did.
Okay, so the NAR settlement is what we're obviously going to be talking about today. And, you know, what I really want to talk about first, though, is about the bad press, because I don't think, well, maybe you guys have already heard this, and a lot of you, I'm sure, have heard a lot of this, but there is a lot of bad press out there regarding the NAR settlement, regarding real estate brokers, regarding what you do. I know that we've talked about it for a long time now, about how brokers have to be more proactive as far as getting out in front of their clients, helping them understand what we do in their transactions, talking about value propositions and everything as well. But you can see some of the things that we're seeing in the industry here. We're seeing Wall Street Journal reported that they expect a 30% decline in commissions. State of the Union, I'm going to pull this up real quick. Can you see that, honey?
Yes.
Okay, so this comes from the White House. This is actually a transcript from the President of the United States State of the Union address. And somebody sent this to me because I think it's telling as to what you guys are dealing with. First of all, they attack title companies, so my wife loves that. But the second thing is, you see here, it says, in addition, last week, the National Association of Realtors agreed for the first time that Americans can negotiate lower commissions when they buy or sell their homes. And then you see there's applause there. Well, first of all, that's just completely inaccurate. Commissions have always been negotiable. They've always been able to negotiate different commissions. But that's the misinformation, is that somehow there's been this cartel that has been charging certain fees and not allowing brokers to take anything less. And you see it goes on to say, on a typical home purchase, that alone could save folks an average of $10,000 on the sale or purchase. And then my favorite, I'm calling on realtors to follow through on lowering their commissions to protect home buyers. So, essentially what that says to me is that the federal government, as high as the president of the United States, doesn't believe you guys earn the commissions that you earn. That's what it's saying. And you can see that has filtrated its way into the Department of Justice, the plaintiffs' lawyers. We're seeing it in the media with some of the things that have been said, which I think is ironic, because I've never heard of the president calling on Congress to reduce all of their wages based on the fact so they could decrease the deficit that they put in place. But nonetheless, they're calling on you guys to take a hit on your wages while the price and inflation of things goes up across the board. I want to share this other one too, because I think it's interesting as well. And I'm hoping, honey, hopefully you guys can hear this. But here we go. This is a clip from Karine Jean-Pierre, who's the press secretary for the president of the United States. And here's what she said.
There was a settlement in the National Association of Realtor States that effectively settled 6% commission.
Say that again. Can you start on
There was a settlement in the National Association of Realtor States that effectively ended the 6% commission on the house sales. Fighting, administration made a lot about fees and costs and consumer costs. What has been tracking this case and any reaction to the settlement?
So I can't speak to the settlement. Obviously, you're talking about junk fees and how important it is that
This is kind of in line with those things. We're seeing that effectively the 6% commission is going away.
their wealth, what they've been able to incur to the consumers. So look, it is very important. The president has always said he's going to stand up for Americans, and he believes corporations obviously should pay their fair share here, and not treat Americans like suckers. He has said that over and over again.
So apparently you guys are treating the American people as suckers. That's, in case you guys weren't wondering exactly what that means. It's very frustrating to me to see something like this coming from as high levels as the president of the United States and his press secretary, saying that you guys are treating people like suckers. It seems like they think that realtors are these corporations that get this large amount of money and have been fleecing the American public for years, which we all know is to be untrue. But that is the perception that's out there. And, it's gotten so bad that what happened is that the settlement was originally supposed to be released at 10 a.m. on Friday, when all the articles and everything else hit. It was supposed to not be released until 10 a.m. And the reason for that is that NAR had built that into the settlement agreement so that they would have time to put their own messaging out at the same time. So the plaintiffs could put their messaging out, they could put their messaging out and talk about how we didn't do anything wrong. This is a way of us settling, moving forward, etc. The plaintiffs released it 4 hours early in violation of the settlement agreement they signed. So that is why we're on defense now. The NAR press release has gone out regarding misinformation, but you guys are also, you now have a bunch of clients that are now receiving postcards about the settlement. You're probably getting all sorts of questions about, well, what does this mean? Should I go ahead and sign it? Or do I need to do anything? How much money am I going to get? And we're going to talk about that in a little bit, but these are all issues you guys are going to have to deal with in this new world ever since the post-settlement. So why did NAR settle? Well, there's several reasons. Okay, so first of all, the appeal. So we know that there was a bad ruling in the Burnett case back in October, or whatever it was, seems like a year ago, in which they got a settlement of $1.6 billion or something along those lines. Antitrust violations are actually tripled. So NAR was, first of all, after having that bad ruling, was faced with a $4.7 billion bond in order to go to appeal. And for a company or an entity that is only worth about $1 billion to begin with, you can see where $4.7 billion bond might have been difficult for them to post in order to get to their appeal and try and have the appellate court hear this. But even if they could have gotten to that you know, there could have been some things that happened as far as the appellate court reducing the amount that they needed to put in a bond, or the court reducing the amount of judgment, or not even awarding triple damages. So there were things they could have done. So this was not alone non-overcomable. This they could have probably moved forward, but there was other things that were happening. So in addition, you saw the mounting lawsuits that were occurring across the country, several of them in Texas, and just it seemed like every time you opened Inman or some other publication, it was about another association of realtors, another brokerage firm, another franchise getting sued over this. In fact, there was a team that was sued in Texas. So, you know, so there was a lot of lawsuits that were getting added, and NAR was being named in all of those. So then again, in addition to dealing with the bond, they now had to deal with the legal fees of trying to take care of these other lawsuits. Now, they had moved to merge all those lawsuits together, and I think that action might have been successful at some point. But again, there was a lot of that going on. Probably one of the things that was most pressing to NAR, and a part of this is some speculation, was that there was a settlement in what is called the MLS PIN case. Now, this is a case where we had an MLS that was sued for antitrust violations. The plaintiffs and the defendant, which was the MLS, had agreed to a settlement. It was some amount of money paid over time or whatever it was, but it didn't have anything to do with commissions. And so they settled this case, and the Department of Justice sent in a motion for an interested party and essentially intervened in the middle of that settlement and said, we're opposed to the court granting this settlement because we believe there needs to be a decoupling. And so at the heart of the MLS, or I'm sorry, at the heart of the Department of Justice's concerns is the fact that they believe brokers that have these offers of compensation, listing broker has commission, offers compensation to a buyer broker, was by itself antitrust violations. That is where I think the majority of the pain came from NAR. As I heard, the Department of Justice was having conversations with other MLSs. They had interjected in this MLS PIN settlement. And so the writing was on the wall for NAR that they were going to have to do something. But the other big issue that NAR had as far as settling this was pressure from its members. There was a lot of members that were pushing for NAR to settle these cases. There was also, I think, that probably hurt them. And again, I don't have any gripes for what people do for their own companies. Everybody's got to make their own business decisions. But when you had franchises settling out early, then that sent a message to the plaintiffs that they had something here, that they should be able to get more money out of this. And it made it more difficult for NAR to negotiate a reasonable settlement or to negotiate something different than what they ended up with. So those are the pressures and everything that NAR was under and why they settled it. What I want to talk about now, though, is what the settlement does, because I've heard a lot of people talking about how NAR threw them under the bus. Guys, I don't see it that way. You see all the pressures that NAR was under. You see the issues that they had, but at the end of the day, they ended up paying out $418 million over 5 years. And that is a substantial sum. But what did they get for it? The first one is probably the biggest deal, is that they got releases for every broker and every brokerage firm with less than $2 billion in total transaction volume for 2022. What I learned in a call that I was on with NAR was that what these plaintiffs were doing is they were going down the ladder. So they started with what they thought is the biggest franchises. And then, as you know, after the Burnett case was resolved, or there was a jury verdict in the Burnett case, they immediately filed against a bunch of other franchises. And what I'm getting from NAR and the settlement language and everything else is that this wasn't going to be done. Once they got through that group, they were going to find another group. And once they got through that group, they were going to find another group. So what NAR negotiated was a release for every broker, every brokerage firm under $2 billion. And so that really is significant as to what you guys got out of this. You don't have to worry about clients or people coming back and suing you under antitrust. The ones you have to worry about is anybody that opts out, but I just don't see that as being a large group of people. Excuse me, I'm sorry about that. So additionally, brokerage firms with more than $2 billion in transaction volume, which amounts to about 100 companies across the nation, they gave them an opt-in, which means that those companies can opt in to try and be a part of this settlement. There's a cost involved. The cost is pretty dang high. And it'll be interesting to see what comes from that. But the purpose of that for NAR was to try and give those companies an option to try and find some of that protection and to give them a route to start negotiating instead of being sued first. The MLSs all have an opt-in provision as well. Those that are owned by the realtors have an Appendix B opt-in, and those that are not owned by realtors have Appendix D as an opt-in. All of those are going to require different things and practice changes, which we're going to talk about here in a minute. And then obviously the franchises that have already settled, you see the ones that we have there now, they have their own settlement agreement. It's independent from what NAR did, but the practice standards are going to apply to them as well. This still has to be approved by the court. I've heard a lot of people wondering if it's going to be approved or not. I'm starting to believe that it might. From what I'm understanding from the class action lawsuits, because they were able to bring in all these co-leads, if you ever looked at the settlement, which is 108 pages of fun, it has a list of the co-lead counsel on it. And what it looks like to me is this was an orchestrated effect by all these guys to begin with in order to put this in place. Or if it wasn't orchestrated to begin with, it certainly is now. And it sounds like they feel pretty comfortable that they can settle out all those other cases with this settlement. At least that's what I'm hearing. There's a chance it won't be settled, but I don't know as that matters. And we'll talk about why here in a minute, but it does still need to be approved by the court. So here's our practice changes. So what it did here is that, first of all, these practice changes are going into effect in July of 2024. And what this settlement agreement says is that it goes into effect no later than the date of class notice. That is not approval of the settlement agreement. That is class notice. And if I go back to what class notice means, it says class notice must not be provided earlier than 120 days following the filing of the first motion for preliminary approval. So the motion for preliminary approval is expected to be filed sometime this week if it hasn't been filed already. I haven't heard, but that doesn't mean it hasn't been done. So within 120 days after that is going to be class notice. Notice that is not approval of the settlement. So these practice changes actually go into effect prior to the court approving the settlement agreement and goes into effect 120 days after class notice. So that's why you're hearing July 2024 as the deadline for everybody to do this, because that's April, May, June, July. That's 120 days. So that's what you can expect. What does it do? Biggest one it does that everybody realizes is eliminate and prohibits the offers of compensation. And I'll tell you, they spend 5 paragraphs talking about how it eliminates the offer of compensation. It says that you can't agree to not create, facilitate, or support non-MLS mechanisms for, NAR can't do that, or realtors or MLS participants can't create, facilitate, or support a non-MLS mechanism for offers of compensation. It also says realtor MLSs cannot provide data or data feeds if it's to create an offer of compensation. Offers of compensation you can only do on your own listings in your brokerage firm. So you can have a web page for them. We're going to talk about some of this stuff here in a minute, but I'm just going through what the settlement says. Additionally, it requires MLS participants to enter into a written agreement before buyer tours any home. Okay, I know there's been a lot of talk about this nationally. The problem is that is inconsistent with state law. And so what the settlement agreement says is that you as MLS participants or realtors are required to have a written agreement with the buyer before you go and look at a home, unless it's inconsistent with state law. In Colorado, it's inconsistent. Colorado has a requirement or has ability or has statutes that say that you can work with a buyer by doing a broker's disclosure to buyer and act as a transaction broker without entering into a buyer listing contract. So that provision, while it may not apply to us, I think you guys want to treat it like it does, because without it, you're going to have some complications when it comes to receiving compensation. And we're going to talk about that here in a minute. It also says that your agreement must disclose the amount of compensation. Compensation must be objectively ascertained and not open-ended, cannot exceed the amount agreed to in the agreement. Our next point is practice changes. You cannot represent services are free or available at no cost. I don't think we do that a lot in Colorado, so I don't think that's going to be a big deal. You must also conspicuously disclose to sellers and obtain approval for any payment or offer to another broker. So the sellers have to have something that's disclosed to them. Additionally, you have to disclose to clients that commissions are not set by law and are fully negotiable. And you have to do that either in the listing contract, you have to do it in a pre-closing disclosure, if any, which we don't have one, or another disclosure if all of those are government forms. So we'll talk about that here in a minute as well. Must not filter out or restrict MLS listings based on compensation. You know, we've talked about this before. That's a violation of your duties, whether it's uniform or fiduciary, to your buyer. If you were to not show them something strictly because you didn't like the offer of compensation is. So this, to me, again, hasn't changed anything about what we've been talking about for years as far as a broker's duty to their buyer. Offers of compensation are not prohibited if they're off the MLS, which gives some people these ideas because brokers are very creative people. And I'm going to tell you, I wouldn't get creative here. Sellers offering buyer concessions, but cannot be limited to commissions. So this is another thing it said, is that sellers can offer what I call seller concessions. The settlement calls it buyer concessions, but they can offer seller concessions that can include a portion or all of the broker's commission. And frankly, I see that probably being the mechanism under MLS as to how people tell people whether the seller is willing to offer compensation or not. But keep in mind, it cannot be limited to commissions. So that offer, the seller concessions, if a buyer comes without a broker or something, they still are eligible for getting those concessions, even if they don't have a broker to pay. This one I love here is that, you know, so paragraph 59 says the obligations under this settlement agreement terminate in 7 years. So what? We're seeing that they're hammering you guys over offers of compensation and everything. Do you really think there's a world in which the MLS is going to go back to the way it was, even if it is the settlement's over? Because all you're doing is setting yourself up for another antitrust lawsuit. So I know that there's talk about the fact that it expires in 7 years. I'm telling you, the practices that are going to change out of the settlement are here to stay. And so we got to wrap our heads around, what does that mean? What do we do with it? And how do we protect our businesses moving forward? Okay, so what does that mean? So let's talk about the changes that I see coming that need to be effective in July of 2024, if not sooner. First of all, I want to talk about division of insurance or division of real estate. So the division of real estate is not a party to the settlement agreement. Everything in the settlement agreement says, unless inconsistent with state law, unless prohibited by state law, unless done by state law. So keep in mind, there is literally nothing in the settlement agreement that would require the division of real estate to act. All right. So that's where I want to start from. Now, I have been told that the division of real estate is currently sent the settlement agreement over to the Attorney General's office, and the Attorney General's office is now reviewing the settlement agreement to decide if there are changes that need to be made to the forms. But keep in mind, they don't have to do anything. So what I want to warn you is this. So first of all, if we're lucky, the division of real estate will act, and we will have changes to our forms, and we'll talk about what those changes probably need to do. But I'm not sure they're going to be able to do so by July. Maybe they will, maybe they won't. It'll depend on how fast the forms committee can get through there, how fast the commission can approve changes, how fast the division of real estate wants to put these things up. And yes, I serve on the forms committee, but this is going to be a decision that comes from the division, not from anybody on the forms committee. I don't know what's going to happen. So from that perspective, I want you guys to understand what you're going to have to change in your businesses in case the division doesn't act. Okay. And if they do act, great, then those are things you don't have to do. But if they do not act, here are the things you need to look at in your business. So first of all, we know that there's no offers of compensation. I want to talk about what that means because I've heard people say, well, maybe what I'll do is I'll list co-ops on my brokerage firm website. Okay, you can do that. What good does it do you is my question. Because keep in mind that the power of the offer of compensation under the MLS was that you guys signed participant agreements when you joined the MLS that said, I agree to pay, I agree to sell. There was an agreement that if there was an offer of compensation made in the MLS, that the listing broker was agreeing to pay the buyer broker if they were procuring cause. When you list your co-ops on your listing pages, does everybody see that those agreements are not in place? And it's not going to give you an agreement that, oh, they're automatically obligated to now pay me. So while I think that that isn't necessarily a bad practice, and I certainly don't have a problem with brokers listing co-ops on their pages if that's what you want to do, I do not think it's going to do what you guys think it's going to do. I don't think it's going to create that obligation for payment. And so we're going to have another mechanism, which we'll talk about here in a minute. Third-party websites, I've heard of people saying, well, you know what we're going to do is I have a great idea. What we're going to do is we're going to start a third-party company. And what this third-party company is going to do is they're going to take all this aggregate, these listings, and they're going to put them together. And then they're going to get everybody's co-ops and they can feed them in there. Do you guys see what you just did? If you do that, you just created the new lawsuit. NAR's not going to care because they say, hey, we had nothing to do with it. We're out. Colorado Association of Realtors is going to say, we had nothing to do with it. MLS is going to say, we had nothing to do with it. So brokers, if that is where you're heading, that you think you're going to create these third-party websites and have everybody push in their offers of compensation and create a new mechanism for sharing commissions, you are begging to be sued again. So I want to warn you, that's not a great idea. Another one I've heard is, well, what we're going to do is we're going to list it on showing time. You think the MLS that just settled their risk of a lawsuit is going to be happy with condoning the ability of you guys putting out those offer of compensations through showing time? I think they'll pull it down lickety split is what I think will happen. But more important, why does showing time now want to be the target for this new mechanism by which we have offers of compensation? So I want you to see that, you know, these ideas are not going to work. Okay. And it's not the way that we get there. And we'll talk about how we get there. I'm not going to just tell you, hey, there's no solutions and the sky is falling, because that's not the truth. But we have these other things. We don't have these contractual obligations when we have these other mechanisms. The other one I've heard is unbundling fees. What brokers need to start doing is they need to start unbundling fees and services so that they can just charge to enter it in the MLS. Can't do that in Colorado. That is illegal under oh gosh, I can't remember the name of the case, but Vizzy. It was illegal under Vizzy because you can't do that. You can't split your services or unbundle your services. So the way that we do business is going to be the way we do business, period. But keep in mind that when we're talking the offers of compensation, that contractual obligation is just not there in any of these mechanisms that we've been talking about. What else is going to have to change is the seller listing contract. If the commission doesn't do it for you in time, you're going to need to put in your additional provisions that says commissions are negotiable, because that was one of the big things that came out of the settlement agreement, is that has to be in all listing contracts. The other thing it says is that sellers have to approve for offer to buyer brokers have to approve those. Our contracts already do that. Our contracts are very clear as to what commission is being charged and what portion of that is being offered as a buyer broker compensation. So that one is already actually taken care of in the forms the way they're drafted today. You will need to, in your listing contracts, put something in that just says that commissions are negotiable. Okay, buyer listing contracts. So again, we have to add commissions are negotiable. That's something that you're going to have to put in if the division of real estate doesn't act in time. The commission amount has to be included in there. You guys already do that. There's an amount in there in the success fee. The one thing I want to warn you against is that I tend to see buyer listing contracts that have a range in them. Oh, it's going to be between X and Y%. Stop doing that. It has to be a specific dollar amount of whatever you believe your value to be. That is the number that has to be in there. Likewise, the amount has to be objective, which means that it has to be a specific amount. You can't just say that it's open-ended. Anything above X, that doesn't work, guys. It's going to have to be a specific amount. The other thing that's in there that is not in our listing contract is that it has to be compensation in excess of an amount. You can't receive compensation in excess of what you're charging in there. The way our contracts are written now, it gives you permission to receive more. I don't know if that meets the terms of the NAR settlement or not with the language that's in there. It'll be interesting to see what the Attorney General thinks of this or what the Forms Committee does with it as far as that's concerned. But if it was me, you have a provision that has a success fee in it, I would use it. I would make sure that you put in the amount that you believe your value is. I would also probably put in additional provisions that commissions are negotiable, and I would probably put in that the broker will not accept any compensation in excess of the success fee in paragraph 7. That's how I would probably handle this. I have here checkbox 7.3.1. It's this simple. You guys got to start checking the box in 731. 731 is the checkbox that says listing broker or seller may pay, buyer is obligated to pay. And the reason I say that is because when the offer of compensation goes away, there is no more protection for buyer broker commissions. There's no protection in the listing or in the website of the listing broker. There's no protection in statements that a broker may have made. There's no protections in the MLS that says they're offering seller concessions. Those are not protections for a buyer broker compensation. We don't have the protections of the MLS rules anymore. So what you're going to have to do is you're going to have to check the box in 731 that says buyer is obligated to pay, listing broker or seller may pay, buyer is obligated to pay. And what that does for you guys is something that was put into rules a long time ago, is it says that if it is a negotiation between the buyer and seller over their commission, then the buyer and seller can agree on what to do with the commission. In other words, the buyer can ask the seller to shift their obligation over to the seller. On behalf of buyer, seller agrees to pay X dollars to buyer broker's brokerage firm. Okay, that is how you can get there. And that is what gives you more protection for the buyer broker getting paid. Because now it's a contractual obligation between the buyer and seller that once it goes to closing, the title company will see it in additional provisions and put it on your settlement statements. It's really the only way that buyer brokers are going to have any surety that they're going to get paid. Sorry, I have this cough lingering that I can't get rid of. But I've heard a lot of questions about commission agreements. I'll tell you, division or the Forms Committee right now is looking at creating a commission agreement. Probably need one, probably a good idea. I don't think they work for you guys as well as everybody thinks they're going to work. And let me show you why. Okay. So let's say that you have a buyer that you're representing. You go ahead and sign a listing contract, but you decide to check the box the buyer is not obligated to pay. And the buyer finds a property that they love. They say, oh my gosh, I love this property. I want to make an offer on it. And so I call up Jill and I say, hey, Jill, are you offering compensation on this? And Jill says, well, yes, as a matter of fact, I am. But we're in an era like COVID where people are getting 20 and 30 offers on a home. And so I say, oh, great. So I send over my commission agreement so that Jill can sign it and send it back to me. And she doesn't send it back to me and she doesn't sign it. And I'm sitting there with the offer waiting to present it to Jill, but I need my commission agreement first because I want to make sure that I get paid. And then next thing you know, I call up Jill and say, hey, I haven't seen that commission agreement. Where is it? And Jill says, oh, I'm sorry. We accepted another offer already. Did I breach my obligations to my buyer? Absolutely. Do you see where this is a problem? And my concern with commission agreements, while I think they work well in commercial, I think residential moves way too fast. And what I mean by that is that you guys have markets at times where you're getting multiple offers in, and the buyer broker, if he sits and waits to get a commission agreement back before he submits his buyer's offer, he probably breached his obligations to his buyer because his buyer's going to say, wait a minute, I lost out. Okay. So guys, even if the commission agreement comes, I'm pleading with you, please use your contract. Please use your buyer listing contract. Got to check the box 731, got to put it in the contract. That is really the best way to protect your commission. And I'll tell you, there's another problem with this, and we're going to talk about that here in a little bit. Okay, so what about the fallout? So first of all, we talked about how we're going to see a number of postcards that are delivered to your clients. Couple things. Number one, I will tell you that the sellers are going to get pennies compared to what the lawyers get on this settlement. Okay, typically the lawyers get about 40% of whatever they settle. My guess is that the settlement is probably going to be somewhere in the neighborhood or the range of $600, $700 million by the time it's all done, maybe more. And, so the attorneys are going to take a lot of that. And then you have a seller class that is, 2016 to 2020 across the entire nation. So my guess is that they're not going to get a lot, but we really shouldn't be opining on that. If you have clients that are approaching you with the postcards, a couple things. Number one, I don't mind you telling them, we don't think we did anything wrong, but NAR settled it to have surety so that we didn't have all this upheaval in our industry. Number two, make sure your clients know what you do for them. Also tell them what NAR does for them as far as protecting property rights, because I don't think a lot of clients really understand what our trade association as well as what the brokers do in defending property rights. And number three, I wouldn't tell them about the amount that they're going to get. I would just say, if you want to opt in, you're certainly welcome to do so. You're probably part of the class. You might get something out of it. And they say, well, how much do you think I'll get? Say, you know what? I have no idea. I will tell you my experience with class actions is that it'll probably be less than $100, but hey, I don't really know either. So I guess we'll see. Maybe there's more to this than I think, but you are going to have to get ready for the postcards because they're already being delivered. I've heard of them in Summit County, Grand Junction, Fort Collins, and those were even areas that weren't even named under the Murrow case. So be prepared for that. Second thing is, and this is why I say we got to have buyer listing contracts, there's no more procuring cause. Right now, under the offer of compensation in the MLS, if you have a buyer that you're working with and you show them the property and you negotiate a contract and you maybe show them comps and you set in motion a chain of events that led to the purchase of the property. But let's say you never had a buyer listing contract. And then after you had submitted the offer, the buyer ghosts you and goes to another broker. And that broker writes a contract on the same terms as the ones that you wrote. Under our current system, you could say to the listing broker, hey, wait a minute, I'm procuring cause, they're not. I have a right to arbitrate this. The listing broker would probably freeze the money and say, okay, you guys go battle it out and figure it out. You don't have that anymore because procuring offer of compensation goes, so does procuring cause. And that's why I'm saying it is so important that you have buyer listing contracts and check the box that the buyer is obligated to pay, because it's literally the only thing you have left. Obviously, with procuring cause going away, that means arbitration is going to be very limited. What the Association of Realtors arbitration says is that arbitration is required if it's a dispute between realtors. Well, our disputes are shifting because procuring cause is going away. Our disputes might be with our clients, whether it's the buyer or whether it's the seller who didn't pay. So I don't see arbitration being as effective or being used as much as it was in the past. Other fallout, FHA and VA buyers. FHA isn't as bad because FHA allows the seller to pay the buyer's broker in FHA transactions. I've heard some people say differently. I've researched it. You can still shift that provision over there. The problem with VA is that what VA says is that a buyer broker, or a veteran cannot pay the buyer broker directly for commission, which incidentally is interesting because isn't that essentially the Department of Veteran Affairs saying that they condoned the offer of compensation in the way that realtors have been doing compensation for the past decades? Didn't that, because they're saying, no, you can't pay it, veteran, because we know there's an offer of compensation over here that the buyer broker can collect. So it's interesting that the federal government has literally condoned this practice for decades, but now all of a sudden the DOJ is saying it's a problem. In those instances where you're representing VA buyers, a couple things. Number one, you still have to have a buyer listing contract. You still should check the box that the buyer is obligated to pay. And the reason is because that allows you to put it into the contract. Okay. And I would put on behalf of buyer, seller agrees to pay. I've heard people asking, well, can we put it in the contract about the amount that the seller will pay for VA? Guys, those provisions in the seller listing contract and the contract to buy and sell are not made for commission. They were made for loan costs and fees. So I think you're still better off referencing in additional provisions that says on behalf of buyer, seller agrees to pay X amount of dollars to the buyer broker's brokerage firm. If you want to put in there, because it's a VA buyer, that says buyer is not allowed to pay this under VA guidelines, that is fine with me. But I do think they are independent of 4.5.3. More importantly, what I'm concerned about is somebody sliding in this big number in 4.5.3 and the seller feeling like they got misled. So keep it out of the listing contracts and the contract to buy and sell as far as those amounts that the seller is paying on behalf of the buyer, and put it in additional provisions so it's clear that the seller is paying it. And if it's a VA buyer, I'm fine with you putting in buyer cannot pay it. Okay. I will tell you that what I've heard is NAR is currently working on, particularly VA, about trying to change that practice of saying that veterans by policy cannot pay that fee. So my hope is that at some point we're going to hear that has changed, but as it sits today, that is how it is. So again, buyer listing contract, check the box, buyer is obligated to pay, draft it into the contract. Now the question comes up when the seller comes back and says, I'm refusing to pay it. The conversation with the veteran to me is pretty straightforward. It's, look, you have an obligation under our contract to pay this. The seller is unwilling to pay it, so it means you really can't buy this house. But more importantly, is the house really worth it if the seller is requiring you to pay me? Because keep in mind, they set the price at fair market value, which usually includes buyer broker compensation, and now they want a windfall. And we have got to get better at helping sellers and buyers understand that our market price has included buyer and seller compensation for decades. And so every time the seller has a price that they're setting, it includes a cost of sale, which is typically commissions. And that needs to be replicated. I think one of the things that I didn't put it on here, but one of the things I've heard about is, what is this going to do to appraisers? I don't know, but I'm hoping what the MLSs are going to do is that they're going to start putting in a data field for commissions so that you guys, when you're doing your CMAs or the appraisers are doing their appraisals, they can adjust to pay apples to apples to see what's happening there, just like they do with seller concessions after a property sells. And that is not a violation under the settlement agreement for them to put in data points. It's a violation if they put it in to make it so that it's an offer of compensation. I get this question a lot about builders. I don't think anything's really changed with builders. Builders, you got to be there present anyways, and you got to get a commission agreement. That's going to be the same as it's always been. Get your commission agreement, go to the first meeting with your clients when you're with the builders, and make sure that you get that commission agreement in place. Typically, builders don't have procuring cause anyways, because the one they have listed is not the one the buyer ends up buying. So I don't see builders changing a lot. The last thing I want to talk about, and this is somewhat important, is E&O insurance. So the way E&O insurance works is it says that you have E&O insurance for your negligence, provided you received or anticipated receiving a commission. Now, up until this point, that hasn't been a big deal because we had the offer of compensation. There's always been commission involved, and we could always figure out a way that it worked. But remember back when we were talking about the buyer broker, they doesn't sign a buyer listing contract or signs a buyer listing contract and says buyer is not obligated to pay. And this is why I say buyer broker agreements are so important, is because let's say that I say, oh gosh, I don't want to ask my buyer for an agreement because that's hard. And so I say, you know what I'm going to do? I'm going to give him a broker disclosure to buyer. I'm going to represent him as a transaction broker because I'm allowed to do that under Colorado law, and the settlement doesn't say I can violate state law. Okay, so you represent the buyer under a broker's disclosure to buyer, and you go to the house and you make an offer on the house and you send in the commission agreement over to Jill and say, hey, can I get a commission agreement? She's like, oh yeah, let me think about it and I'll get back with you, because she's kind of flighty and doesn't want to tell you what she's going to do with it. And so you go ahead and you're waiting, but you're like, what? I don't want to breach my obligations to my buyer because I understand that they want the property. And I understand I got to submit the offer. So you write up the offer and you submit it to Jill. And Jill says, oh yeah, by the way, I'm not giving you a commission agreement. I'm working for free. Everybody see that? I got no offer of compensation coming from my buyer, or I got no offer of compensation in the MLS. I got no agreement by my buyer to pay me my commission. And I got no agreement by the listing broker to pay my commission. And I got no agreement by the seller to pay my commission. So I am literally working for free. And E&O insurance says if you're not working for a commission, you have no coverage. So I call it no good deed goes unpunished. I help my buyer buy the property. He closes. He has a problem with the house and he sues me. I get to pay for it myself. No attorney fees, no indemnity. It's all on me personally. So guys, this is why you got to do the buyer listing contracts. Even though this, I think the settlement may not mandate it in Colorado. I think you got to treat it like it does, because it really is the only way to protect yourselves in so many ways. Number one, protect your commission, but number two, also to make sure that you have E&O insurance for your policies. So that is what I have. I went through that very fast. I realized that, but are there any questions, honey? Because I'm sure there's none.
We do.
Oh, imagine that.
Okay, I'm just going to kind of roll through these as fast as I can. Steve would like to understand why the 7-year limitation was a part of the settlement.
Well, I wasn't in the room when they did this, Steve, so I don't really know. My guess is that they had to have a duration. There's other things in here that NAR has to do too. They have to provide training materials and they have to go out and do things. So my guess is it's probably more for those reasons. But I can tell you, once our practice changes with the offer of compensation and some of these other things, we ain't going back. And all of you that are raising your hands, please put your questions in the Q&A because we're not going to be able to call on you.
Kate says, what is the recourse or consequences since the plaintiff leaked or violated the settlement agreement? Do you anticipate this agreement to be approved by the courts or expect amendments or renegotiations?
Well, I don't think their breach is going to be material enough that it's going to change anything with the settlement agreement. I just know that NAR was very angry that they didn't get an opportunity to put the message out there about what happened, because in their minds, they settled this to help their members. And what's happened is that all of the bad press has meant all their members thinking that they threw them under the bus. And I think that was really unfortunate. I don't have a crystal ball. And again, I'm not in any of these rooms with these conversations. I doubt it's going to get renegotiated. And from what I'm hearing, the expectation is pretty high that it's going to get approved. But guys, I don't practice class action lawsuits. I really don't have any idea.
There was a question about the title insurance piece. I can include that in my follow-up email. Did you want to touch on that at all, Damian?
Oh, I'll touch on it. So, I mean, I think the title industry was shocked to learn that apparently they have been causing affordable housing crisis because of the $2,000 or whatever it is they charge in title insurance premiums. I'm sure it's gone up, but whatever it is. The reality is there was a pilot program that was in place that allowed for refinances, FHA, VA, that they could go and get an attorney opinion letter instead of getting a title insurance policy. And the concept was, hey, we'll have an attorney give us an attorney opinion letter for less money than what we would get for an insurance policy. But the reality is that the insurance policies are not that expensive in Colorado compared to other places. And more importantly, what attorney in their right mind is going to do that opinion letter? Hey, I'd love to get sued. Please sue me. That sounds great. And I'll do it for less than what the title companies are doing. That's the dumbest thing I've ever heard. But nonetheless, that's what the policy is that they're trying to implement. And maybe they're going to come up with something different, but that was what they were trying to do originally. And from what I can tell, that's probably what they were referring to in the State of the Union address.
Does the settlement release non-realtors?
The only people that were sued were realtors. And so it does release MLS participants. So if you are an MLS participant that is not a realtor, then yes, it releases them too.
If there were other settlement agreements for other companies, why are they listed on the NAR settlement agreement too?
I don't understand the question.
Yeah, Tom, can you maybe rephrase that one for us?
We got 48 questions. We're not going to get through all of them.
Yeah. How do we do open houses when a buyer comes to the door?
So I've heard this one a lot too. So buyer comes to the door for an open house. Guys, like I said, Colorado allows you guys to do a broker's disclosure to buyer and be a TB. So I think that practice is still applicable, and that might be the one area where it's okay. But I'm going to tell you, why are you spending a lot of time with a buyer that wants to go look at other properties if they don't want to sign an agreement? Because that is literally the only thing that protects your commission.
Can a buyer choose to not see a home based on the seller compensation?
Yeah, I mean, so the thing that was frustrated about with the settlement is it talks about that brokers can't steer buyers away from properties based on the offer of compensation. And that's, I get it. I mean, that's a fiduciary duty thing, but the reality is that most of the time it's the buyer that says, I don't want to go look at that property because then I'd have to pay your commission and I don't want to pay it, which is another reason that I think we need to explain to sellers, there is value to them offering something to a buyer broker. And frankly, the amount they offer is going to depend on the market we're in. If we're in a seller's market like we were in COVID, you can see the amount that they offer to the buyer broker is going to be much less than if we're in a buyer's market like after the Great Recession, where they were pleading for people to come buy their homes. So that's a conversation to have with the seller as well.
Can we list the co-op fee agent on the closing instructions? That way the closing company is instructed to pay it at time of closing to the selling company and the buyer's agent has it in writing.
Okay. I guess you could do that, but brokers aren't a party to the closing instructions. So how are you inserting yourself in there? And if you're inserting yourself as on behalf of buyer, why wouldn't you just do it in the contract? I don't quite understand why we want to go to closing instructions and complicate things.
If our buyer says they can only afford to buy a house that offers a broker co-op, can they direct us as their agent to only show them homes that are offering a buyer co-op? I'm
Well, first of
concerned
all,
for first-time home buyers who don't have extra cash.
no, I understand. The first-time home buyers are the ones that are going to get hurt the most by this. But you know, guys, you're all talking about being able to see these offers of compensation. They're not going to be in the MLS anymore. And how do you find out whether there's an offer of compensation? Are you going to get on the phone and call every single listing broker of every house that you're going to take the buyer to look at? Or wouldn't it be easier to just have a buyer listing contract that says buyer's obligated to pay, go look at all the houses that they want to look at, and then put in the contract that on behalf of buyer, seller agrees to pay? Wouldn't that be an easier mechanism than trying to be on the phone with a whole bunch of listing brokers asking them, hey, are you going to offer compensation? Oh, you are. Can you sign my commission agreement? I think we're making it too complicated trying to replicate what we had before. And you guys got to get your mindset out. The offer of compensation is dead and you need to pivot. And to me, the easy pivot is to do the buyer listing contract and then ask the seller to pay it. And if the seller refuses to pay, say, well, buyer, remember we talked about this? They're refusing to pay it. But I'll tell you, I envision a lot of sellers that are going to potentially say, we don't want to offer any compensation, and we'll wait until we see if the buyer broker is smart enough to put it in the offer. That's my guess as to what's going to happen. But that's why I wouldn't sit there and spin your wheels with listing brokers and sellers about whether they're willing to pay it or not. My guess is a seller is willing to pay it depending on the price you offer.
Jesse says the top of the listing contract state compensation charged by brokerage firms is not set by law. Such charges are established by each real estate brokerage firm. Is that sufficient?
Where was that again? Did he say?
Top of the listing contracts. Compensation charged by brokerage firms is not set by law.
Well, I would put it in separately, guys. I don't know. It's funny. I just reviewed these listing contracts and I don't remember seeing it. So thanks a lot, Jesse, for making me look silly. I really appreciate that. But I don't know. I think I would put it in separately just to make sure.
Can you please repeat what you would note in the additional provisions on the buyer listing contract?
All it has to be, guys, is simple. It just says real estate commissions are not set by law and are negotiable. So don't get around the wheel on what has to be in there. It's not complicated. I just say that real estate commissions are negotiable and not set by law. I think it just has to be that simple. And if it's on there already, that might actually do it. But I think I would want to put in additional provisions just to make sure that any plaintiff's lawyer or somebody that sees it knows that you're complying.
Can you write into an offer in additional provisions that the buyer instructs the seller to pay whatever percent?
Yes.
And for clarification, so we cannot accept any additional commissions or bonuses offered.
That seems to be what the settlement agreement is saying, is that you can't. So what I would do is this, guys, is if you, and I see it come up on new builds where you might put in X percent and for some reason the new build is offering Y percent. And sometimes those correlate to the same thing and sometimes they don't. if it's going to be more, then I would go ahead and you're going to have to disclose it to your client anyways. I mean, that's required under our state law. And so when you're disclosing it, I'd probably do an amend extend with broker at that point and just say that the buyer is authorizing you to receive that additional amount. And as long as the buyer is authorizing you to receive it, no problem.
Can't the agreement, if they come up with one, be submitted with the offer? If we call the agent to find out what or if they're paying, so we know before we present the offer.
Yeah, you could do that. I don't know why you want to do that though. So what happens if they sign your offer and they don't sign the commission agreement? Now what?
How's this going to play out with regards to lending?
No idea. I don't know. I know that there's talks with lenders about rolling it in so that the buyer can roll it into their loans. I find that interesting. And the only reason I find that interesting is that you have a bunch of conventional loans that could be 5% down. FHA is typically 3% down. VA is sometimes lower than that. And so if the buyer pays a price and then they roll their commission into their loan, it feels like we're getting back to the no equity in property days is what it feels like to me. So I just don't know whether lenders are going to have an appetite for that or not. So I have no idea.
Oh, so what happens if you're unable to show a client of yours a property, you're sick or on vacation, and you ask another agent to show on your behalf? If that buyer wants to write on that home, does that negate your buyer's broker agreement if the other broker writes it?
So first of all, if there's rules about if you go on vacation, and if you go on vacation and you turn it over to another broker, then you should be designating them as a designated broker to help with the buyer, because when they go look at houses, if they're doing anything that requires a real estate license, they have to have their own working relationship. So they're going to have to be designated on your listing contract. If they're in another brokerage firm, then you should have a co-listing agreement that designates them on your listing contract. Otherwise, they would have to do their own. And then if you gave it to somebody that wants to cut your throat, I would choose somebody different to give it to next time.
How would this impact a referral to another broker, regardless of buyer or seller being referred?
The referrals isn't going to be impacted by this. If you refer to another broker, you still get your referral fee. That has nothing to do with what we're talking about.
As a listing broker, do we have to verify the commission in the buyer agency agreement?
No, you do not. That is not your job. That is between the buyer and the buyer's broker.
Okay. Getting through as many of these as we can here. Let's see. If the buyer agent compensation is noted in the MLS upfront as a seller concession, is the amount limited to the amount of the buyer's closing costs, or are the sellers able to pay more on behalf of the buyer?
One more time.
If the buyer agent compensation is noted in the MLS upfront as a seller concession, is the amount limited to the amount of the buyer's closing costs, or are the sellers able to pay more on behalf of the buyer?
So first of all, the offer of paying seller concessions or buyer concessions, whatever you want to call them in the MLS, is not a contract, guys, and it's not an obligation. This is not an offer of compensation. There are no contracts anymore. So what that means is that whatever the contract says is what the contract says. So whatever the seller agrees to pay is what the seller agrees to pay, but it's got to be in the contract.
When writing a new listing or buyer contract before July, do we need to be adding that language that all commissions are negotiable in additional provisions?
I would go ahead and start now. There's no reason not to. And particularly since you don't know what the division of real estate is going to do, and those listing contracts might be in place still. It's not that hard. It doesn't change your agreement. So why not do it?
Until July, if a co-op compensation is listed in the MLS, they are required to pay this, correct?
Yes, as long as the co-op commission is still in there, you still have that agreement, but after July, you won't have it anymore.
We were planning to address this with our clients via our newsletter. Anything we should say or avoid entirely?
Like I said, I would stay away from standard commissions. I would stay away from setting the amounts. I would stay away from how much they're going to get in their settlement. What I really want is for clients to understand that this is an industry, and the people that they think are fleecing them are not corporations. It's a bunch of people trying to feed their families, because I think that got lost in the messaging.
Currently in the exclusive rights to buy or sell, what do we enter in the section about compensation? Only for the listing agent, and in section 21, add buyer compensation is negotiable.
I don't know what that means. Where? I don't see it.
I'm sure in probably the listing contract about compensation. Are they just listing now the listing agent compensation in section 29?
So again, I don't quite understand the question, but I'll just reiterate for like the 100th time, is that the exclusive right to buy and exclusive right to sell have your compensation already built into them. Both of them do. The only thing you really need to add is that real estate commissions are not set by law and are negotiable. That's all that needs to go in additional provisions. And it doesn't have to be about the buyer's compensation or anything else. It's just commissions in general are negotiable.
It's an interesting question. Will the MLS go away? Since they do not have the authority to enforce commissions, what is to keep realtors from just listing in Zillow?
I got to tell you guys, I don't know. I'm hoping that the MLS has come up with something that's their value proposition. It would be a sad day if they went away, because if they go away, we're going to see a lot of bloodletting in our industry. And I don't know what they're going to do. I really don't, but I understand the concern. I understand what people are saying, but we'll see what the MLSs do to pivot, because they're going to have to pivot too.
Do you think commission rates will decrease?
I don't have any idea. I am interested to see what happens, but I personally don't feel like brokers are overpaid. I think you guys work hard for your money. I think your biggest problem is that your clients don't see what you do. And I know that I'm talking to the 1,200 on this call or whatever it is, that are the ones that are diligent about representing their clients and do a real good job. But I do see a lot of brokers going away that cannot do their value propositions and do not maybe do as much or add as much value to their clients. So to me, it's going to be an interesting couple of years as this works its way through. But like I said, I don't feel like you guys have been overpaid. So it'll be interesting to see how this works.
We'll just snag a couple more here. We are seeing agents already making compensation requests on contracts now. Some are sending emails, some are putting it in line, additional brokers acknowledgments and compensation disclosure. Should we already be making these changes, or are people just freaking out?
Look, I don't mind you guys starting to implement everything now. There's no sense in not doing it now. I mean, if you're going to do it, then I would probably send an email that says that the offer or the compensation listed in additional provisions supersedes, we waive any rights to under the offer of compensation if the seller agrees to this offer. I'll tell you guys, if you're putting it after the contract and the commission disclosure, not a contract, not going to get paid. If you're getting an email or something back, not a contract, may not get paid. So you better be checking what you're relying on for your commission if it is not in the contract. And I hope I'm making that clear, because I really think that's where you guys got to go.
Okay, we are going to start having a lot of single agent transactions, meaning listing agents acting as agents for sellers and buyers as customers. Don't you think buyers will get screwed in these scenarios, and Colorado will be forced to allow dual agencies?
Guys, we're not going back to dual agency. That's garbage. Don't even kid yourselves that dual agency is a thing. And I've heard that a couple times, and I have no idea who created that rumor, but it is dumb. We already have transaction broker. We already have the ability for a listing broker to be on both sides of the transaction by virtue of transaction broker. That is what it's going to be for brokers that are on both sides of the transaction. But I got to tell you, this concept that buyer brokers all of a sudden are going to go straight to the listing broker and buy properties, I think is kind of ridiculous too. The reason we have buyer agency is because back in the 90s, buyers demanded it. They said, hey, wait a minute. We got all these brokers working for the seller and nobody's representing our interest. And so we want buyer agency to make sure we're protected. We want buyer agency to make sure that we have an advocate. And we've already had buyers that go to you guys directly, and they usually say this. They say, I don't have a broker, so I want you to take X off of the purchase price. So that's already happening. And I just don't see this as increasing it. Maybe it'll increase it a little bit, but I feel like buyers want representation. That's why in 1994, they passed the designated brokerage law anyways. So, and no, we will never go back to dual agency, no matter how much people pretend that that's an actual thing.
Okay, I had one more question I was going to snag. I know there are lots of questions here, guys. I lost it, but the question was in regards to, could there be a fair housing violation if you're trying to qualify a buyer to see if they can afford to pay you to represent them?
Well, I don't know I think what you guys need to do as buyer agents is you need to set expectations with your buyer. I think you need to talk about compensation. I think you need to talk about ways that you get paid. I think you need to talk about the fact that, hey, we're checking this box that says you're obligated to pay, but my goal is to put it in the contract and ask the seller to pay it. I think that's okay. And I think you also need to talk to them about the fact that if the seller doesn't pay it, that they need to decide whether if the house is worth it or not. And if the house is worth it, they may want to pay you, and that's fine. But if the house isn't worth it, if they have to pay you and come up with a down payment, then they probably need to move on. So you qualifying them as far as their ability to pay you is not what I would do, but qualifying them from the standpoint of helping them understand how our industry works, how you get paid, why you get paid, what your value is, I think is certainly something. And you got to spend more time with the buyers, helping them understand what your role in this process is.
That's perfect. Guys, Damian has another appointment I know he has to get to, so we're going to cut it off there. Thank you for all the great questions. Thanks for your participation. Thanks for joining us. I hope that offered some clarification to you all today. We want to be here for you, be a resource for you. We will get through this transition in our business yet again. And please do think of me and Heritage and your rep if you have a transaction that we could support you on here in the near future. Thank you so much, and we will see you all very soon.